We're going to go into the first panel, which will be a panel we framed the legal panel. So I'd like to invite our 5 panelists up to the front. So we have 5 panelists. I will be introducing them before I ask them to speak. I haven't told them yet the order. Now I'm going to tell you, and they might hear it at the same time. But John Baker will be the first to speak, and then Sandy Levinson, and then Barbara Perry, Nick Dranius, and I'm sorry, Nick, is that the way I say your name? Perfect. Great. And then Professor Lawrence Tribe. So I'd like to invite John Baker, if you'd like, to begin, and if you want to come up here, it's fine.
Thank you, Larry.
I'll tell you when you
Can
go.
this is, okay, thank you. Thank you.
I'm sorry, I didn't introduce you. I want to introduce you. I'm sorry, I didn't do the only job I have up here, which is to introduce people. So, John Baker is a distinguished scholar in residence at Catholic University. Of the American Law School, and he's a professor emeritus at Louisiana State University Law School, where he had been the Dale Bennett Professor of Law. He has taught everywhere, including Georgetown, Tulane, George Mason, Pepperdine, New York Law School, Hong Kong University, and University of Dallas. He's a visiting professor at University of Lyon in France since 1999, and has lectured all across the world. He received his honors from the University of Michigan Law School, and graduated magna cum laude from the University of Dallas. He has earned a PhD in political thought from the University of London. So now I would formally like to welcome you back to the stage.
Thank you very much. It's a great pleasure to be here. The first thing I'd like to do is to applaud our co-chairmen for their emphasis on civilized debate. The understanding at the founding was that a republic required that kind of public debate. And in order to debate civilly, you have to agree on something in order to disagree civilly. And the fundamental thing that seems to unite everyone is a dissatisfaction with our representation in Washington. And it may be because they're not doing what Mark Meckler said was his job. He was describing really the function of a mediator. That is, to translate between two sides. And the founders never expected that we would all agree, and one of the reasons they created a large republic really was to spread us out. But they did expect our leaders to be able to talk to one another. And so I'm very happy to join in this conversation today about an Article 5 convention. Professor Lessig has proposed that we go through a seriatim from the application process to the selection, to the rules, to the ratification. But of course, these 4 areas raise so many questions we couldn't possibly discuss them all in the time we have, certainly not in the 10 minutes allotted to each. So I want to break it down into 3 general areas as a way to approach it. First of all, I think we have to understand what the challenge in discussing the whole question is. And 2, I would like to suggest a framework as to how we approach that discussion. And 3, attempt briefly to apply that framework in the context of the 4 general areas that Professor Lessig has asked us to address. You know, the more you study the Constitutional Convention option, as it is generally called, although I think more appropriately called the Article 5 Convention, the more questions that arise, and certainly Professor Tribe has listed them in great detail when he testified before Congress some years ago. But you know, it wasn't so complicated for the framers, or at least it didn't appear to be if you read the Federalist and the few references that are made there in Federalist 43 and 85. You know, it was looked on by Madison in 43 that both sides, in a sense, the states and the federal government, can propose amendments. And in Federalist 85, I think there's a little language worth reading, because it makes it clear, as the text makes clear, I think, but not everyone believes the text sometimes, that is mandatory on Congress. There shouldn't be an issue. As 85 says, nothing in this particular is left to the discretion of that body, meaning Congress. I think that's an important point when we look at an Article 5 convention. Congress's discretion is very limited, and one can question on each of the 4 points what discretion it really has. But when we look at just the first question of the application, it appears from the text that all the states have to do is apply. But in practice, most of the applications since the beginning have been rather specific. They've identified a particular area that the state wanted to address in a convention. So we have a series of questions. I'll just tick off some of them. Do the applications that are specific, do they count at all? And which, if they count, how do you count them together? And who does the counting? And when you get the count, do they count even if they aren't specific? As I'll talk about at the end, there's one way to count in which we already have enough to call a convention. Normally, when you have a constitutional text, you also have implementing legislation that follows. That's what the first Congress largely did, was to implement the institutions laid out in the Constitution. But the whole point about a convention is that it's an end run, possibly, around the Congress. So it raises a second question about when the Article 5 says that Congress shall call, what's in the call? What can they do? I want to turn to the second point in our framework for discussing it. Now, for me, as quoted an originalist, I want to know what the original meaning of the text is. Now, there are many who will disagree with that approach, I know. Some will simply say, well, there's no way to know because they gave us this little bit of language and we can't tell anything from it. And there are others who will say, well, I don't care what we know about it because the original meaning is not important to me, or to others maybe. But to me it is important, and that's the way I have to approach it. So for me, I want to begin with the notion that this is a foundational issue, obviously. And for American trained lawyers, meaning trained lawyers, you look for a case. We can't find any cases on Article 5 conventions because we don't have any. Well, wait a minute. How did the Marshall Court decide cases when, after all, they didn't have any cases? Well, they read the text, but you know, you can read the text in different ways even back then. That was, there were those who framed the Constitution who had a notion of a certain structure, and there were those who disagreed with it who had a different structure in mind. But it's pretty clear when you look at the foundational cases of the Marshall Court, Marbury, Martin, Gibbons, and McCulloch, that more or less they are following the framework understood by the framers as expressed in the Federalist. Indeed, Marbury basically plagiarizes Federalist 78. But today we're further away from that, and we don't as often get foundational cases. We've had some, the term limits case in particular, and where we have very few in the way of cases to look at it, and we have to go back and look at structure and history. The one area in which we do have some cases here relates to ratification. And some people have suggested that maybe the ratification process for an Article 5 convention is different from what it might be when Congress proposes the amendment. But I would suggest to you that if you look at the text, there is no different treatment on ratification depending upon whether Congress proposes or whether the states propose. Therefore, at least in that area, it seems to me that Congress has a great deal of power, as suggested by the cases, I think, properly interpreting that particular part of Article 5. My third point, because I'm running out of time, is how would I apply these things in terms of the framework? And I want to take the issues in reverse order. The ratification process, as I've said already, I think is pretty much the same, meaning that ratifications that whether or not they lapse over time, whether or not states can reject after having accepted, all of those kinds of questions, some of which have come before the courts, have by and large been deferred to the Congress, and I think that that would be the case on ratification. On the rules and scope, however, I think it's a different question. That is, Congress gets to call, but what's in a call? Certainly time, place, and details like that. But the real question is scope. Can Congress limit? And what about the fear of a runaway convention? I won't read it right now because of time, but if you go to Federalist 39, you'll see a discussion where it's fairly clear where Madison's talking about the fact that the amendment process is neither wholly national nor wholly federal. And he outlines the fact that you can't completely change the Constitution right there in 39. It seems to me that the selection of the conventioneers is a matter completely left to the states, unlike ratification. It seems to me also because it is the counter in terms of what was, as Madison described, a compound republic, partly federal, partly national. This is the federal part. On the federal part, each state gets an equal vote. It seems to me that that's fairly clear by implication. Whether or not the convention could change that is another matter. The last part is the one I started with, the application process, I think the most difficult one. And I would suggest this, that if you really want to push some of these issues, one of the ways to do it might be to follow the suggestion that Professor Paulson, then of the University of Minnesota, made some years ago. He wrote several articles claiming that if you ignore the specifics on the applications, we have more than enough states that over the years have called for a constitutional convention. And he said Congress is obliged now, this is 15 years ago, to call a convention. I haven't heard that one was called unless I missed something. It's interesting to focus on the word obliged, because I think we have to understand that 200 years ago and even 150 years ago, it didn't mean the same thing. The fact that you were obliged didn't mean that anybody could enforce it. We have lots of interesting questions about what the courts could or could not do. But there is a notion that Congress is obliged to do certain things. But if Congress is obliged, how are we going to force them to do it? I doubt that many of these questions can actually be litigated for reasons that have to do with, one, justiciability, and two, the whole question of confrontation among the branches. But if people are serious about a constitutional convention or an Article 5 convention, something I personally don't support, I do support, however, a strong discussion. One could lobby your members of Congress now and say you're obliged to do it. I doubt Congress is going to do it. Why? Because the thrust of the Article 5 convention is the calling from the states. And the reality is that many of the states passed constitutional requests for Article 5 conventions in response to particular requests, and many of them, frankly, weren't serious about it. It's kind of a throwaway to certain groups that want some action out of their legislature when they're mad about something. So it really still, I think, comes down to the states, and whether or not one ever gets called, I think that a vigorous discussion, even one that frightens people, is good, because it forces us to consider the kind of questions we are considering here today. Thank you very much.
Thank you. Thank you, and I'm especially grateful that you kept to the time that we had allocated. That's very helpful. The second speaker, Sandy Levinson, is the person who introduced me first to the questions around an Article 5 convention. He's a member of the faculties of the University of Texas Law School and the Department of Government of the University of Texas at Austin. And in the fall, he's going to be a visiting professor at both Harvard and Yale. He's the author of Our Undemocratic Constitution, Where the Constitution Goes Wrong, and a forthcoming book which he has tentatively titled America the Ungovernable, which will come out from Oxford in 2012. So I'd like to welcome Sandy to his speech.
Thank you. I, too, am extremely grateful to be here. I will say that I unequivocally do support a new constitutional convention, so I'm not an agnostic on that issue. And so let me go through very quickly, 2 minutes each, 5 of the areas that Mr. Baker very helpfully brought to our attention. First of all, the application process. I agree that if 2/3 of the states petition Congress to call a convention, Congress has no choice in the matter. Now, there are the side questions that have already been brought up, and there's very, very interesting materials prepared by the Barry Goldwater Institute, if I have the name right, on the question, which has already been adverted to, do the petitions have to concern the same subject or separate subjects? They take a very cautious view, which may in fact be the correct view, that it really does have to be the same subject, so that if 20 states want a convention specifically for a balanced budget amendment and another 20 states want a convention specifically for a term limits amendment, then you don't have 2/3 of the state calling for a convention in an Article 5 sense. Quite frankly, I don't have much of a dog in that particular hunt because I don't think, as a matter of practical political fact, 2/3 of the states are likely to agree on a call either for a specific convention around specific matters, or for the kind of convention I want, which is a no-holds-barred, everything is conceivably on the table convention. But I certainly agree it raises interesting legal and theoretical questions. Should states give these petitions? Under what circumstances would Congress be required to honor them? What I want is for Congress to call a convention. I think it is a perfectly plausible reading of Article 5 to say that Congress must call a convention should they get petitions from 2/3 of the states. But I also would say, for a variety of structural reasons, that Congress may call a convention should it believe that it is necessary and proper to help the country, even save the country. I share the sense that Mr. Meckler expressed, though, as he suggested, we probably have different substantive views, but I do share the sense that this is a time of crisis. These are the times that try men's souls, and it seems to me that if Congress were to call a convention, there is no serious constitutional issue about whether they would have the power. Now, it is fanciful to imagine Congress calling a convention unless it's pressured to do so. And my model would have the pressure coming from we the people, both the left and the right. I presume that centrists define themselves as being pretty satisfied with the status quo, so the idea of a convention would have no appeal to them. But for better and possibly for worse, our politics are getting more polarized, in part with the sense that the government really is not functioning. There's the polling data of 12% support for Congress. I would hypothesize, on the basis of what I've read about the American Revolution, which I find a fascinating moment in our history for obvious reasons, that there would have been higher support for the government of His Majesty King George III had public opinion polls been available then than there is currently. And I don't mean to be cracking a joke. I think this is a very serious issue with regard to the basic legitimacy of our political system. So for me, the application would come when millions of American citizens in a variety of groups, some from the right, some from the left, who have learned that respectful communication is possible and who actually continue to have some faith in democracy. The thing that most troubles me with regard to the fears expressed of a runaway convention, and I certainly hear them from my friends and family on the left who think that I'm crazy to want a convention, but I gather that one hears the same fears expressed from the right that, my friends will just control the convention and run away with it. I think that this really does express a deep fear of we the people, of popular democracy. I think this kind of fear inevitably leads to what political scientists call an elite-driven view of politics and what might less generously be called a Leninist view of politics. That is, a fundamental mistrust in the ability of ordinary Americans to talk with one another, to disagree with one another, often very bitterly, but in fact to work for what James Madison, naively or not, called the common good, what Michael Sandel today would call the common good. And I think that's the deep issue underlying this. Do we the people have faith in we the people? I think that is the fundamental issue that we're addressing. So, as I say, my model, my fantasy, is that millions of we the people would exercise their First Amendment right to petition their governors for redress of grievances. Some states might do this as well. I'm not opposed to states passing petitions. It's just that I in no way view states as necessary actors in the application process, only under certain conditions sufficient actors. So the application comes from we the people. The call is by Congress, acting in response to popular democracy. Then there is the all-important issue of the choice of delegates. And I've decided that if I'm willing to hang for a lamb, I may as well be willing to hang for a sheep. I've started down the road of calling for a constitutional convention, so let's go all the way in thinking it through. And my view is that the best way to select delegates is by lottery. That is a national citizen jury. The prospect of elections, I think, raises all sorts of obvious problems that, in fact, sparks the disillusionment with government, and that Larry has written and spoken so eloquently about. This would be either a fantasy or a nightmare of single-issue political groups trying to capture the convention for their own purposes. They have a First Amendment right to be committed to single issues. They have a First Amendment right to be passionate. I fully assume that if a random sample is used to choose 700 people, good and true, that there would be a decent percentage of zealots, and I don't use that term pejoratively, on a variety of issues, but there would be certainly many more people who were not so committed to particular issues and perhaps more willing to compromise with regard to issues. This also obviously does express a naive belief that ordinary people could rise to the occasion. People now who, because they have incorporated the wisdom of economists, that it's irrational to participate in politics, it's irrational to vote because the marginal utility of your participation is basically zero if you think it through. So, of course, you should tend your private garden. I think that wisdom of economists runs counter to a rich vision of Democratic or little r Republican politics, but I think it's perfectly correct in its analysis of incentives. But I think if you plucked out the most obscure American and said, you're going to have a chance to wrestle with the most fundamental issues and to decide how your children and grandchildren would live, they would rise to the occasion. The fact is, we're not talking about rocket science. We're talking about making fundamental value judgments that require some information, but you can get the information during a convention by holding hearings, by listening to other people. So I would, in fact, emulate ancient Athens or the way we pick juries by doing it at random. What would the scope be? I've already tipped my hand on that. Another sheep goes down. The citizen jury would be able to think of everything. I am very, very confident. In my bleakest moments, I really do not believe there is a movement to reinstate slavery in America. I don't really think you need to fear that. I don't think you need to fear most, perhaps all, of what is generally put forth. If among the 700 people chosen at random, one of them is kind of crazy in terms of suggesting something truly off the charts, I have no doubt that will be rejected and we can go on peacefully after that. So I would have everything discussable. And then what would the source of legitimacy be? Well, the source of legitimacy would be ultimately what the legitimacy of the Philadelphia Convention was. That this would be the ultimate reality television show. It would be on C-SPAN. It would go on for months, maybe even a year and a half or 2 years. This is not a weekend sort of activity. If in watching our fellow citizens engage in respectful dialogue, you said, they are my fellow Americans. And even though I disagree with their particular solutions in this case, they really are good citizens. And we're going to have to make compromises. Then I think it would have legitimacy. If they ended up at each other's throats, if it just kind of disintegrated, then there would be no legitimacy and we would go on as before. I'm very, very happy that Mr. Baker adverted to what I think is the single most important decision by the United States Supreme Court in our history, that is McCulloch versus Maryland. And I think it's the single most important decision because of a sentence that Felix Frankfurter once said is the most important sentence in our history. We must never forget it is a constitution we are expounding. And quite frankly, I find that mysterious. Why would anybody think it's even a very interesting sentence? Because of course it's a constitution they're expounding. It's not the Internal Revenue Code or whatever. But then he went on to say 7 paragraphs later, it is a constitution designed to endure, not like the Articles of Confederation, which lasted a grand total of 6 years. And it must be adapted to the various crises of human affairs. Well, I think that one of the things that unites us, whatever our political differences, is that we are in a term of crisis. This is one of the foreseeable crises of human affairs, and the Constitution has to be adapted. Now, some of us, I suspect Professor Tribe and myself, are more generous. I mean, McCulloch versus Maryland is one of the great exercises of constitutional adaptation. Others of you may reject McCulloch, which I think is at the heart of many of the current debates. But what we're talking about today is not controversial theories of constitutional interpretation. We're talking about the kind of adaptation that doesn't raise those kinds of lawyers' questions. Rather, they raise questions about what it means to be an active citizen in 2011.
Great. Thank you very much, Senator. Barbara Perry is a senior fellow in the Presidential Oral History Program at the University of Virginia's Miller Center. She was before the Carter Glass Professor of Government at Sweetbriar College, where she founded the Center for Civic Renewal. She was Judicial Fellow at the United States Supreme Court, where she received the Tom C. Clark Award. And she served as a Senior Fellow for Civics Education at the University of Louisville's McConnell Center, and is a non-residential fellow there. She is the author of 8 books, including a co-author of one of the most important books I think that there is about this issue, and so I'd like to invite her to come up and share her particular political science perspective on this legal question of the convention.
Well, the first observation that I wanted to make before beginning my formal remarks is that I was sitting out in the audience during the welcoming session, and I was sitting straight out from Justice William Brennan's portrait, and I think perhaps in the spirit of today and this weekend's unique meeting here, he's leaning slightly to the right, so I think we can take that as a good sign. Thank you, Professor Lessig, for welcoming us to this very beautiful and historic university. And I also want to thank Selena Gray for her expert logistical planning. She made it all look very easy, and those of us who plan meetings such as this know that it's anything but. And I especially want to thank all of you in the audience for taking your weekend to be here, because I think it shows how much you care about our country and our system. When Professor Lessig invited me to participate in this conference, I had a rather time machine sort of experience. And lest you think that I was flashed back to 1787 and the Philadelphia Convention, I was actually flashed back not quite so far, but to 1987 and the bicentennial of the product of that Philadelphia Convention. As you see, in 1987, we were celebrating, of course, the 200-year-old document that we still are governed by, and calls were mounting at that time for a balanced budget amendment to the Constitution. And so in about 1987, my undergraduate mentor at the University of Louisville, Paul Weber, called me and asked if I might like to co-author a book with him. And as I was at that time a newly minted PhD in political science, a novice assistant professor with my dissertation not yet published, I said, yes, I'll co-author a book with you. And then I said, what are we writing on? And he said, constitutional conventions. This was Paul. Paul had a tremendous amount of enthusiasm about everything, and I had to say that my heart sank, and I said, what about them? Not trying to be too snarky, but I said, what about them? And he said, we shouldn't be afraid of them. And I said, but I am afraid of them. And Paul was a former Jesuit priest, and he just had a contagious serenity about him and an eternal optimism. And he said, don't worry. So I pretended that I was on a debate team and I had been handed a resolution in which I didn't wholeheartedly believe, and we began writing. And so in 1989, Paul and I published this book called Unfounded Fears, Myths and Realities of a Constitutional Convention. 6 years ago, next month, Paul passed away, still not having made me a believer. But I recently wrote to Professor Lessig to say that I had read his 2009 article in The Nation called How to Get Our Democracy Back. And I said to Professor Lessig that he may have convinced me that Paul was right all along. So my assignment today is to present briefly what were really Paul's responses to fears of a runaway convention. And remember, Paul was working, as I was, on this book as political scientist, and so Paul was focusing specifically on what he thought were political constraints on the scope of a new convention that might be called in the modern era. And he had 6 of them, and they're in, interestingly enough, chapter 6 of this book. So the first one Paul mentioned was the character of delegates to the convention. Now, Paul assumed that they would be elected rather than, in Sandy's view, to be chosen randomly. Paul thought they would be elected, and he thought that they would be men and women of character, and therefore they would not run away. Second, he thought that media attention to the discrepancies between what these people would have campaigned on as delegates or potential delegates, their campaign statements and promises, that media would focus on those if there were discrepancy between those and what they ultimately were talking about at this convention and ultimately what they decided at the convention. Number 3, he thought that the number of delegates and the divisions within the convention itself, which would make it, he thought, extraordinarily difficult for one faction or a radical position to prevail. Sort of a Madison Federalist Paper number 10 approach, where you'd have factions fighting each other, but you wouldn't have a bad faction in the end rise above the others. Fourthly, he thought that delegates' awareness that the convention results, of course, still had to be presented to Congress, which might not forward any amendments that were too radical or that went beyond the convention mandate. Paul saw that as a political constraint. And then fifthly, he thought that the Supreme Court could declare certain actions beyond the constitutional powers of the convention. So he thought that was another check on the process. And sixth and finally, he thought the need to get the proposed amendment ratified, of course, ultimately by 38 states, as Sandy mentioned, would be the ultimate check. Now, what I wanted to end with today was to say that I think part of the reason that I wasn't convinced by Paul in the late 1980s is that I could never get over the hurdle of seeing the need to call a convention for a specific public policy issue. Those public policy issues, for me, never rose to the level of needing a constitutional convention to solve them. And in the late 80s, as I wrote the chapters I was assigned, I developed a chart on state legislative applications to Congress to call a constitutional convention and the subjects that those applications mentioned. In other words, the reasons the states wanted to call, at that time, constitutional conventions. And these were the top 5 or 6. Obviously, the Balanced Budget Amendment. Busing for racial integration, that was a major issue that caused my home state of Kentucky to call for a constitutional convention. The federal courts had ordered Louisville Public Schools to begin busing for racial integration. Bans on abortion. The line item veto power, which is a little bit more procedural, of course, than a specific policy issue. Judicial appointments, some states wanted to change the way federal judges are appointed. And then taxation. There were calls in the 70s and the 80s to have a constitutional convention to redo the tax policies in this country. But I think Professor Lessig's article that I just mentioned, How to Get Our Democracy Back, as I say, was more convincing to me on an institutional basis than on a specific public policy issue. The 1787 convention, remember, founded a republic, a representative democracy. It didn't found a direct democracy. It founded a republic, or as they called it, a democratic republic. But let's face it, it was more republican, small r, than it was democratic with a small d. And in fact, the founders created what I think is a beautiful balance, almost a Newtonian sort of balance, with the major principles that we hold so dear in our Constitution. And during my fellowship at the Supreme Court in the mid-90s, I was there just at the time that the Soviet Union had collapsed. We had new democracies developing in the former Soviet republics and around Eastern Europe. And one of my jobs as a judicial fellow was to take visiting politicians, judges, dignitaries from all around the world who came to the United States to learn about our Constitution and particularly about our Supreme Court. And they view our Constitution and they view our court as the jewel in the crown. And so we have to remember that it is a thing of beauty to other people who don't have democracy. But again, it was this very delicate balance, I think, among separation of powers, checks and balances or checks and counterchecks, and then division of powers among governments through a federal system. But what I've started to think about in reading Professor Lessig's article is that we have many factors that have intervened in these over 200 years since Philadelphia that I think have probably begun to upset and erode this delicate balance. In other words, we've moved more towards the democracy side of the equation than the republic side of the equation. We just simply have more democracy than our founding fathers ever envisioned, and I think that's a good thing, but I'm just saying in terms of procedures and process and this delicate balance that they shaped as more of a republic, we may have now upset the balance to such an extent that we may need to rethink this model. Obviously, we have more media. than they could ever have envisioned. Old and new media, centralized and decentralized media, traditional media and social media. That's another factor that has intervened in these 200 plus years. And Professor Lessig's point in his article is way more money and the impact that money has on our system of democracy, and not for the better. More partisanship, I think, than the founders had anticipated, and certainly more globalism than they could ever have expected. And one other issue, less time. We have less time to address these issues than I think they had the luxury of having in 1787. So I'm not sure that we're trying to get our democracy back, as the title of the article indicated, as much as we are trying to create a more democratic constitution for the 21st century to match the level of democracy that we now have in our system. Thank you.
Thank you. Nick Dranius holds the Clarence J. and Catherine P. Duncan Chair for Constitutional Government and is director of the Joseph and Dorothy Donnelly Muller Center for Constitutional Government at the Goldwater Institute. Dranius successfully led the Goldwater Institute's challenge to the Arizona Clean Elections Law all the way to the Supreme Court. Unfortunately, sorry, I didn't.
Hey, civility.
That was a civil, unfortunately. And he has also authored numerous scholarly articles wide-ranging across the issues of constitutional law. His latest work is called Federalism DIY, Do It Yourself, 10 Ways for States to Check and Balance Washington, which provides specific guidance to legislators and litigators on restoring balance in the relationship between the states and federal government. So I'd like you to join me in welcoming him to add his thoughts.
Well, thank you, Professor Lessig and the esteemed members of the panel, and of course the audience. You know, when I hear about coming together, bipartisanship, cross-ideology, civility between the left and the right, I'm immediately reminded of my experience with Mad Magazine when I was a small child, and particularly the Spy versus Spy cartoon, where the white hat spy and the black hat spy are shaking hands and smiling with each other and holding some sort of weapon behind their back. I'm hoping that in reality that's not what we have here right now. And here's a test to prove that there actually can be substantive policy consensus on the left and the right. I could be wrong if this goes the wrong way, and then I'll sit down. Show of hands, who in this audience thinks that TARP, giving $700 billion in a slush fund to a bunch of Wall Street banks and hedge funds, was a great idea? All right. Who here thinks TARP was a terrible idea? Ta-da! The point is, there is tremendous potential common ground on the left and right on fundamental matters of substance, not merely of process. And this is the ultimate perspective that everyone in Article 5 efforts needs to have. Remember, you've got to get to 38 states. To get to 38 states, you got to have something that sells on both sides of the aisle. But as we've just seen, that something could be fundamental. Now, with that said, let me just explain where I come from and where I've been on this and why I've been on this issue. About a year and a half ago, I watched TARP pass, despite the loud cries of 80% or more of the American public. I watched our elected representatives in Washington on both sides of the aisle saying they were doing their civic duty and ignoring us. And I realized that there had to be some other option than just voting out the same old jokers. I mean, my experience with Alfred E. Newman was confirmed that this is indeed Washington's personification. And it struck me that there had to be some other option. The founders couldn't have envisioned that this is the only way that we handle the abuse of power in the federal government. We just hope that someday we'll get the right bunch of people in there. And I took another look at the Constitution. And I looked at a section that always scared me. You know, on the right, we have our fears. There are monsters under our constitutional bed, and usually they're found under Article 5. But I took another look at it because I realized, if I'm worried about a runaway convention, it doesn't take much more than what I just saw. And if you really step back and think about it, no matter what your ideological perspective, if you want a runaway convention, you can pretty much say that's what the executive branch and the legislative branch and the judicial branch do all the time. Now, why should they have all the fun? But more seriously, I went back to Article 5, and the first thing that struck me in reconsidering, in my desperation, the options that we as citizens have in dealing with the abuse of power in Washington, the first thing I noticed was how intertwined the congressional power to propose amendments and that of the state's power were. They were in the same paragraph, in time, even in places in the same clause. It didn't make any sense to think that there was something inherently different and fundamentally dangerous about the power entrusted to state legislatures in Article 5, but not the power entrusted to Congress. And then I got to thinking, I do claim to be a constitutionalist. And it is in the Constitution that states can initiate the process for amending the Constitution. I have a contradiction to resolve. Not being particularly good at cognitive dissonance, I decided to resolve it. I decided that Article 5 is not that red button of danger that is so shiny, but you can never touch. It's not the fruit of the tree of Eden that we must not ever chew on for fear we might learn things we shouldn't know. It is an essential part of the balance of power between the states and the federal government. And that balance of power is central to preserving our freedom, because even Alexander Hamilton, no fan of states' rights, a big fan of bailing out his banker friends, even Alexander Hamilton in Federalist 28 recognized that the genius of our system more than anything else was the fact that we give the people the option to look out to our agents, the states and the federal government, and throw their weight into the scales of one or the other, depending on who at that moment happen to be the best protectors of our liberty. It is the genius that divides power between two governments in the same geographical area that creates a dynamic decentralization of power that prevents the bad guys from concentrating and seizing and leveraging that power to bad ends. And Article 5 is a critical component of that balance. Indeed, as Professor Baker highlighted, Article 5 was the ultimate sales point to the states in urging them to ratify the Constitution. And how do I know that? Well, first let me ask, how many in this audience are attorneys or would-be attorneys? All right. I'm going to say something, I think everyone who even knows an attorney or seen an attorney, I think we'll all agree with. We will all agree that the final argument of a legal argument is the most important argument. You either win the case or lose the case at the final argument. Well, guess what Federalist 85 is? It is the final argument of the Federalist Papers. It is the last pamphlet designed to convince the states to ratify the Constitution. It is, by its very nature, and many of the founders were indeed lawyers, it is supposed to be the principal reason why the states should ratify the Constitution. If you lose this argument, you've got nothing. What is the focus of Federalist 85? The focus of Federalist 85 is to tell skeptical states you do not need to have another constitutional convention. Why? Because in Article 5 and in its power for you to apply to Congress to call a convention for proposing amendments, that is all you need to erect barriers against an overreaching national government. In Federalist 85, you see simultaneously a distinction drawn between the Article 5 process and a wide-open constitutional convention. It is the alternative to a wide-open constitutional convention, and you see that its purpose is to be used as needed to erect barriers against the national authority. This is the argument that cinched the ratification of the Constitution. And for any constitutionalist to ignore that argument is to ignore the understanding of all of the American people at the time of the founding, and to disregard, more importantly, the wisdom that that reflects. So I would urge everyone here to embrace the Article 5 effort. The Goldwater Institute has come out with a website, www.goldwaterinstitute.org/Article 5 with a V. We go Roman on that. You will find there all of the resources you need so that you don't have to listen to an expert or any expert. You can go to the online Library of Liberty, which has all of the original sources. The reports of proceedings from the Constitutional Convention, the records of the Continental Congress, all the Federalist Papers, all the ratification debates. You can go to the internet and you can become a constitutional expert. And when you do that, you will see that Article 5 is a very clear process. It's no more vague than most of the Constitution. That wasn't supposed to be a punchline. It's really just as definable by the text and background, custom, and history as anything else in the Constitution. And it has the ultimate backstop that will frustrate any crazy idea, and that is the requirement of ratification by 3/4 of the states, 38 states. And if they go the way of the legislative ratification route, as have all but one of the congressionally proposed amendments, that means all it takes is 13 chambers to block any crazy idea that might come out. That means a tiny minority, something on the order of 15% of all state legislators, can block anything. That, more than any other argument I can give you, more than any other original source I can point to, proves there is nothing to fear, that only truly consensus-based ideas will get through this process. And so I would urge you to let go of your fear as I did. Look at the original sources. Don't look to the experts. Become one. You can now. And support the Article 5 movement. Thank you.
Thank you. So, I received an extraordinary number of emails from people after we announced this conference telling me how extremely happy they were that our next speaker would participate, Lawrence Tribe, who is the Carl M. Loeb University Professor and Professor of Constitutional Law at Harvard, where he has taught since 1968. And a university professor is a very distinguished title. Only 70 professors in all of Harvard are university professors, and so this distinguishes him appropriately in our law school. He was actually born in China to Russian Jewish parents. He entered Harvard at the age of 16, graduated summa cum laude in mathematics in 1962 and magna cum laude in law in 1966. He clerked the California and United States Supreme Courts, received tenure at 30, elected to the American Academy of Arts and Sciences at 38, and to the American Philosophical Society in 2010. As the Northwestern Law Review has put it, no one else in American history has simultaneously achieved Tribe's preeminence as a practitioner and scholar of constitutional law. They are certainly right about that. He is the dean of constitutional law in the United States, and I'm extremely honored and happy to be able to welcome him to give his thoughts on the Article 5 Convention.
Thank you very much, Larry. The dean means I'm old, I think. You know, when Barbara was saying that when she was looking at the portrait of Justice Brennan, and she was glad to see he was leaning a little bit to the right. I had always thought he was leaning.
I didn't say I was glad, I just made an observation.
Well, my point is I always thought he was leaning left. It's clear that it's a matter of the perspective from which you are looking. Are you looking at it from Brennan's perspective or that of the audience? You know, framing this issue, as several of my distinguished fellow panelists have, in terms of who's afraid of a runaway or a crazy convention, I think sort of misses the boat, because it assumes we can agree about what a non-runaway convention is. What is this creature? What kinds of state applications, if any? Sandy Levinson thinks you don't need any. Are required to trigger it? Who sets its rules? How do its proposed changes become binding law? Now, some people say that the puzzles are all solved. All you have to do is become your own expert, look at the Federalist Papers, read the text, carefully study 18th century custom and practice. And some of the people who have worked a lot on this have published rather imposing articles with titles like Amending the Constitution by Convention, a complete view of the Founders' Plan. Well, you know, even James Madison, during the Philadelphia Convention, quite famously observed that the Article 5 procedure is dangerously vague. He was sort of an expert, though he didn't have the internet to look things up in. I have to say, it takes more chutzpah than I at least, or should I say chutzpah? It takes more chutzpah than I at least can muster to say, oh no, we've got it all figured out. And it's not as though the unresolved questions about what this creature is are sort of peripheral. I mean, they cut to the very heart of what a new convention is supposed to be and what powers it's supposed to have. And at least 10 such questions seem to me to be really beyond resolution by any generally agreed upon legal or political method. And we just tick them off. May a state application insist that Congress limit the convention's mandate to a single topic or a single amendment? You know, for that matter, if Congress may call a convention independent of state applications, as Sandy Levinson argues it may, then how could state applications possibly constrain the convention's mandate? It seems to me that it couldn't. On the other hand, if applications are constraining, then how are applications proposing related but different topics or amendments to be combined or separated? Suppose they are similar but somewhat different. Do you add them up or do you not add them up? When do you hit the magic number of 2/3? May the convention propose amendments other than those that it was called to consider? May Congress prescribe rules for the convention or limit its powers in any way? And here's a really important one, fundamentally important. May the convention set its own rules independent of Article 5 for how amendments that it proposes may be ratified, the way the Philadelphia Convention did. After all, the Philadelphia Convention was called under a scheme under the Articles that said ratification required unanimity among the states. But they departed from that. A lot of the speakers today have said not to worry. Article 5 says that it takes 38 states to ratify. But what if the convention decides that ratification will be by a national referendum without giving 13 small states a veto power? Certainly, if your idea of a convention is to correct the most fundamental defects in the system, like Sandy Levinson's emphasis in a lot of his writing on the defect that every state has the same number of senators, whether it's a huge state or a small state, it would follow that if you're going to change that, you're going to have to change Article 5 itself, which says that no state can be deprived of its equal suffrage in the Senate without its consent. And if you're going to change that part of Article 5, why not the part of Article 5 that specifies the mode of ratification? Another question, are the states to be equally represented, or does a one-person, one-vote rule apply? And here's a question that could well tie the country in knots for longer than the 18-month running reality show that Sandy Levinson has in mind. What about the District of Columbia? We can't even figure out if the citizens of the district should be able to vote for members of Congress. What's their role in such a convention? Could delegates be bound in advance by legislation or referendum to propose particular amendments or vote in a particular way? Now, if you choose them by lottery, the way Professor Levinson would, it's a little hard to imagine how they could be bound in advance. Could the convention propose amendments by simple majority, or do you need 2/3 or a supermajority? If each state gets one convention vote, must delegates representing a majority of the population nonetheless vote for an amendment in order for it to get proposed? Conversely, if the convention uses a one-person, one-vote formula, must the delegations of 26 states, perhaps including the District of Columbia, nonetheless vote in favor of a proposed amendment? And this is absolutely critical. What role, if any, would the Supreme Court play in resolving conflicts among Congress, state legislatures, governors, referenda, and the convention itself? Barbara assumes, oh yes, we can rely on the court to hold things in check. But can we? The court certainly has assumed that questions about the ratification process are non-justiciable political questions that it can't get involved in. And who would have standing to invoke the court? It's my best guess that the court would stay a million miles away from all of this. Now, there's disagreement not only over the answers to those questions, but over how to go about answering them. It's hardly news that there is deep division, not only on this panel, those who say they're originalists and those like Sandy Levinson who say they're not originalists, on the proper methods of legal and constitutional interpretation. Now, Nick pointed out to some laughter in the room, well, this is no more vague than most of the Constitution, and he didn't intend that as a joke. I'm sure he didn't. Fact is, we all know that there's a lot of stuff in the Constitution that is very vague, very ambivalent. And somebody might say, well, so what's new? Article 5 is no different from the Bill of Rights, the word liberty, the commerce power, but there are some fundamental differences. First of all, we have developed orderly procedures over the past couple of centuries for resolving those ambiguities, but no comparable procedures for resolving these. Second, difficult interpretive questions about the Bill of Rights or the scope of the taxing power or the commerce power tend to arise one at a time, while questions surrounding the convention process would more or less need to be resolved all at once. And third, the stakes in this instance are vastly greater, because what you're doing is putting the whole Constitution up for grabs. You don't have to worry about running away with it in order to say, well, let's see, are we really up to it the way we were lucky enough to have those guys up to it in 1787? I mean, there was a bond that connected them. Even though they differed on issues like slavery, they'd all come out of the Revolution. They were lucky enough to have Hamilton, Madison, Franklin, and they had a George Washington to preside. I don't know what you think about the current cast of political characters, but I look around in vain to see a Hamilton or a Madison, or for that matter, a Franklin or a Jefferson, not to mention a Washington. It's great that we, people of very different views, can talk and converse, but the stakes in this conversation are relatively limited. We may convince ourselves and one another a little, but we haven't put the whole Constitution of the United States on the table, and it's actually served us pretty well. It's not as though it's been a massive failure. We did have to go through a civil war to overcome some of its deficiencies, but I think it's done pretty well by us. There's also a deep contradiction between what some people have to assume in order to favor a convention, to make deep structural changes. They have to assume that it's all up for grabs, that Article 5 is not going to be binding, that, for example, the rule that every state gets the same number of votes isn't going to be binding, and the point of view that others who want a convention for a more substantive purpose, like getting rid of Citizens United, or reducing the powers of the national government, or increasing the powers of the national government, those substantive objectives, the people who favor a convention to do something substantive tend to fall back, as the introductory materials for this conference do, on the idea that it all is going to fit neatly into the existing Article 5 framework that takes 3/4 of the states to ratify. Well, that's an assumption, of course, that you can't make if you really want to put the whole structure up for grabs. Now, there are people like Barbara Perry who argue that even though these legal questions are unanswered, that there are something like half a dozen political constraints, although she included a Supreme Court check as among the political constraints, and I have my doubts about that. There are political constraints that can substitute for the legal ones under our current situation. But it seems to me that the very thing that is said to make a convention essential is the supposed failure of our political process, its polarization, its paralysis, its capture by special interests. And to rely on that supposedly failed process in order to provide a backstop so that putting the whole Constitution on the table up for grabs is a good idea at this point in our history seems to me to be to sort of live in two different worlds at once. One world that says ordinary politics has totally broken down and we can't trust it. And the other world that says we can trust ordinary politics in order to make it a safe bet to put the Constitution on the table up for grabs. Now, it's true, I'm not suggesting that we should never do that. There are times in our history when it was appropriate. I think 1787 was such a time. And the reason is that even though, as Larry Lessig said at the beginning, there were the deepest divisions between those who believed that slavery should persist and those who wanted abolition, there was at least a general agreement on the direction in which we should move, the direction of creating a more perfect union, which is what the preamble talks about. Because there was fear that the Articles of Confederation created too much centrifugal force. We were flying apart. We had succeeded in a revolution, but we really were not going to hold together unless we had a more central government. George Washington couldn't even raise money for the troops for the Continental Army without volunteers from the states. We needed to move in that direction. But today, whatever the depth of our disagreements, the vectors point in different directions. Some of us in this room want a weaker central government and more states' rights. Others want a central government that is more capable of countering corporate power over our politics. We don't even agree in what direction to go. And so I'm afraid that at this moment in our history, calling a convention a creature whose fundamental composition, whose DNA we barely understand, would not make a lot of sense, especially because I'm not ready to give up even on politics, believe it or not. Take the views of the Tea Party. It's been remarkably successful in moving the Republican Party in the direction that it likes, in moving the Republican caucus in a direction that takes more seriously the problems of national debt. Hasn't gotten rid of Obamacare, but I wouldn't be sure that it won't succeed in doing that. To say at this moment that politics is broken, we have to put the Constitution up for grabs in a new convention seems to me to be risking something that has stood us in enormously good stead over the course of 2 centuries, something that has been the model for the world. American exceptionalism is in large part the result of constitutional exceptionalism. Of course it has to adapt to changing times. I agree with Sandy Levinson that that was the greatest line in the greatest Supreme Court decision of all. A constitution that will endure for the ages. But for the Constitution to endure for the ages, we have to continue the intergenerational conversation that links us to the framers and that enables us to move toward a more perfect union, not necessarily put it all up for grabs, which is why, although I'm trying to have as open a mind as possible about this, the doubts I have about the wisdom of a new convention, not a runaway convention, but any convention, overcome my desire to experiment. And I do want to end by thanking again both Larry Lessig and Mark Meckler, because I think that the conversation they have begun here, whether it leads to more discussion of a convention or not, is something that is long overdue, and I'm proud to be a part of it. Thank you so much.
So I want to exercise the power that Ronald Reagan asserted when he said, "This is my microphone, and I'm going to extend the time of this session until 12:15, so we have a little bit more time for exchange. And I would just open up with a couple of questions that have been so perfectly ripened by Professor Tribe's intervention. And I guess these are questions both to John and to Nick. Both John and Nick both presume that we can imagine two kinds of conventions out there. We could say a constitutional convention in the sense of the thing that gave us the Constitution, and an Article 5 convention, which is thought of as a different creature. And I take it Professor Tribe is skeptical that there's such a distinction, that there's a constitutional convention which has which is as unconstrained or unconstrainable as we saw the original convention to be. So am I right to think that you think there are two creatures here? And if there are, is there something you can say to suggest why we should think one is more constrainable than the other?
If I may. They are clearly two different creatures if you take the founders' own words at face value. The founders, and particularly the James Madison quote that both the John Birch Society and Professor Tribe rely upon in creating concerns about the Article 5 process, that the quote from James Madison that everyone cites to is actually a quote addressed to the dangers of a wide-open constitutional convention and not the Article 5 process that is by its nature more limited, and we know it's more limited by virtue of the fact that it says expressly that the ordinary amendment process cannot alter the state's equal suffrage in the Senate. Now that implies that if you tried to do a strike all and replace the entire Constitution via Article 5, that you, without unanimous consent, could not eliminate the equal suffrage of the states, which implies you cannot eliminate the states, which implies you cannot eliminate the Senate, which implies that if you did the most you possibly could do through the Article 5 process, you'd be left with a structure that looks almost exactly like the Articles of Confederation. And that's not a mistake. That's by design. So the bottom line is this. A constitutional convention that is wide open, or what Madison called plenipotentiary, is not what Article 5 was designed to be. The founders fought against that idea. You can see it in Federalist 85 in particular. That is the specific argument raised. Alexander Hamilton says there's no need for a second constitutional convention because you have adequate powers to initiate constitutional amendments as states through the Article 5 process. Even Patrick Henry, in opposing ratification in I think it was like a 12-hour speech, complained that Article 5 was not a constitutional convention and that it couldn't change the Constitution in all the fundamental ways that he wanted to do. So, historically, textually, from the words of the founders and the ratifiers, there's just no way to conflate the two if you think any of that matters. And that leads to the other question. If you don't think the Constitution matters, if you don't think the text matters, the original meaning matters, then of course you can have any old constitutional convention you want. We could have one right now. That can never be constrained. And that's something I'm not arguing against.
John, did you want to?
I think there is a distinction in terms of what they understood by a convention. I think it can be established, but I don't think there is any way to authoritatively establish that today. I mean, I think academically you can establish it, but as Professor Tribe, I think, has convincingly shown, there's no authority to establish it, and that's where the confusion comes in. There is no ground rule to establish that, and it's because of that that I oppose a constitutional convention. If it were as I think they intended it, I would be comfortable with it, but I don't think it will be as they intended it.
I just got to follow up with that. There has to be a first time for everything. There was a time when, my God, we've given each chamber of Congress rule-making authority. How do we know they're not going to have minority rule? How do we know they're not going to deviate from all the history and practice that existed before? I mean, every question, I suppose I'm sounding like I have chutzpah, but forgive me for this, Professor. I mean, the bottom line is every question you have directed to Article 5, you could target to every single procedure in the lawmaking process when it was first done for the first time. And
So-
that is not a legitimate criticism.
No, it is, because there's been a big difference. At the time of the convention, there was very little case law, and there was custom. Today, we are governed by very little custom, and we're governed by case law. And we have a lot of case law developed over more than 200 years. We don't have this, and we don't have time to do it. There are too many issues up in the air, and there's no authoritative way to resolve it.
So I'd like to ask Barbara, and I'm going to come back to you. Barbara, In your book with Professor Weber, as Professor Tribe suggested, you tried to introduce what you called political constraints that might help address some of the uncertainties that Professor Tribe has enumerated. And I wonder whether that helps us understand whether there is such a distinction between Article 5 conventions and regular conventions, or how that might play out.
I'm not sure about that specific point, but again, I think Paul, being the eternal optimist, everything with the glass was always half full with him. To Professor Tribe's point about the Supreme Court, that, as you remember, was one of Paul's suggested restraints or constraints, that the court could declare certain actions beyond the constitutional powers of the convention. And I just have to say that when we did the book and we looked at Professor Tribe's materials, and even as I hear him express it today, both my heart and head are with him. And as I say, Paul was not convincing me beyond that at the time. But something is happening in our system that I think Professor Lessig has put his finger on, and that I tried to indicate at the end. I can't quite put my finger on it. You're putting your finger on money, particularly, and its impact on Congress. I would just add that, as I say at the end, with all of the other changes that we have had that make this jewel in the crown, our Constitution and the institutions that it created, that they may not be working properly. The system may not be working properly because the inputs are so different now. So I would just say that. And then I also wanted to ask Professor Tribe, I see your point about could we know that the Supreme Court would or wouldn't step in, and you suggested that they wouldn't, who would have standing to bring a case. I used to think that before Bush v. Gore. I didn't think they would step in to Bush v. Gore. So I just wondered about your thoughts on that.
You really know how to hurt a guy. No, there are surprises everywhere. I want to respond primarily to what Nick said. I do agree that there's a difference between an Article 5 convention, which I read the Constitution to contemplate, some creature that would be an Article 5 convention, and a totally new convention of the sort that I think Sandy Levinson, though he can speak for himself, advocates. It's just that I don't know the metes and bounds of those differences. Now, does that lead me to think we should never have another Article 5 convention? No, I agree very much with Nick. There's a first time for everything. And I do believe that there may be certain kinds of systemic breakdowns where a large majority of the people of the United States want something to happen. For example, and I take this just as an example, they want to limit the ability of amassed corporate wealth to dominate American politics. Now, I count myself as part of that group. I've helped people in Congress to introduce an amendment that would try specifically to overturn Citizens United. It was introduced by Donna Edwards just a few days ago. But it may be the case that the very things that make us want to change the influence of corporate money on politics will make it essentially inconceivable that Congress would propose that amendment to the states. Now, if we get that kind of lockdown, which is what I think led, though he can certainly speak for himself, Larry Lessig to suggest the exploration of a new convention, then I think we're at least in the territory where there's perhaps a plausible systemic case for a limited purpose convention, assuming enough people can be convinced that it could be limited. I don't think, and that's why I think it's sort of an interesting question whether we can take the people who favor a convention in that direction, which I would say the left direction, and those who favor a convention to restrict the national debt or a convention to restrict national power over commerce. It's hard for me to imagine how those two vectors can come together. And it's the second impulse, which I think is largely, though I can't speak for the Tea Party, I don't know that I understand all of its philosophies, but I think that that's a large part of what animates the Tea Party. Smaller national government, less taxes, smaller debt. Now, I don't see ordinary politics as incapable of producing that. They've been pretty damn successful in moving in that direction so far. So I don't see that as similar in a structural sense, to the Citizens United problem. And if we're going to limit the experiment of an Article 5 convention to situations where we really have a plausible argument that we are inherently locked out of making a change through the ordinary amendment process, if we're going to limit it in that way, then I don't see that as a plausible occasion for having a convention.
If I may just quickly.
Quickly.
Very quickly.
Very quickly.
First of all, thank you for having the flexibility to acknowledge that there is a point in time for an Article 5 convention. I think one of the most valuable things that could happen out of this conference for folks such as you who are skeptical is to really lay out parameters as to when you would become comfortable. And we could have a debate within those parameters, and you know what? We might find that you're ready for an Article 5 convention. And the other thing is, we were all in this room when 98% of the people in the room said they opposed TARP. Now, there may be pet ways that each the left and the right have, specific legislative proposals that they would prefer in the ideal world to have passed. But we all recognize the core problem, right? And there's got to be a way to think creatively to find a consensus on addressing that core problem. Maybe not the ideal way, but a way that gets us to 38 states.
So I'd just like to ask Sandy one question, then we're going to have questions from the audience, and I'd invite you to fold whatever you want to say into that. Sandy, you've mapped out a different way to think about the power to call a convention. I just wonder if you could just very quickly carry us through the consequences of such a convention. So if there is a convention like that and it proposes amendments, do you believe Congress needs to ratify those amendments by 2/3 before sending it to the states, or you actually think that Congress has the power to directly send them to the states from that convention?
Well, I mean, you look at what happened in 1787, the mandate of Congress suggested that they would engage in review of what the convention did. It didn't. And as Professor Tribe pointed out, it also said, I assume everybody thought going into the convention that Article 13 of the Articles of Confederation would continue to hold, and it didn't. Article 7, in many ways, was the most important article of the original Constitution. I mean, we ignore it now because it is no longer of relevance, except in reminding us what a legitimate body of people can do. And legitimacy, at the end of the day, is not a legal term. It's partly legal, but it really has to do with the polity and the stature of the people and the respect that they have. And, again, kill another sheep. It does seem to me that Article 5 and the requirement for 38 states dooms any truly substantial amendment, right or left. And that, with the Key of Lamar, I believe that we, the people, ultimately would allow a legitimate convention to propose popular ratification. James Madison himself, like most people of that era, recognized or claimed that a basic right of we the people was to alter and abolish our forms of government when they were no longer efficacious. We all have our favorite Federalist papers. I love the end of Federalist 14, where he says that what makes Americans Americans is that we're not bound up in our respect for names or for kind of ancient tradition, but we think for ourselves and forge new paths and learn lessons of experience. So the real question is, what have we learned after 220 years? And it's that, I don't think that everything in the Constitution is defective, but I certainly think that very important parts are defective. And the other really great Federalist paper is Federalist number 40, in which Madison basically justifies the setting aside of restraints imposed by Congress about what revision means, or putting aside the Rhode Island veto with regard to unanimity. And he says, in essence, we're in a time of emergency. And I think there's a certain kind of schizophrenia in some of the discussion that if we really do believe this is a time of crisis or emergency or even exigency in the late 18th century sense, then you really rise to the occasion, which is where the framers are most inspirational. If, on the other hand, you think we should be trapped within what I really do describe as the iron cage of the conventional notion of Article 5, then you've got to believe that all of the talk about emergency, crisis, even exigency is just so much political rhetoric that things are really, good enough. We've muddled through in the past, we'll muddle through in the future, and lighten up.
Okay, so we're going to go to questions, and we have mics here. People can come to the mics and ask your questions. I ask you to identify yourself before you ask your question. I ask you to recognize there are lots of people who want to ask questions. There's not a lot of time, so please keep the speeches to a minimum and questions as powerfully as you can. So from my left, Cenk.
Hi, I'm Cenk Uygur. I'm host of the Young Turks. I'm going to be hosting the political panel where I will probably fundamentally disagree with Professor Tribe on how broken our political system is. So I hope you stick around for that. But I thought you asked the most important legal questions, but I would love to try to begin to get answers, because I think this is, in that sense, the most important panel. So how do we get those answers? Who gets us those answers? For example, how do we choose delegates? Is it a limited or unlimited convention? Et cetera. Who decides that? How do we decide that? Can we begin to answer that?
So let me just begin on that, and anybody else can chime in. Congress presumed, in the last time we came close to this, to have the authority to answer those questions. Senator Hatch had Senate Bill number 40, which extensively addressed all of the procedural, structural questions that the convention would call for. My favorite part of Senate Bill 40 is that it forbid members of Congress from being delegates in the convention. But the presumption, at least going forward, was that that's within the scope of the necessary and proper authority. Is there?
I don't think it is. I think the whole point of the Article 5 convention is to go around Congress, and that Congress's role in the call is very limited.
And let me just second that. You can look at Federalist 43, and it says that the states and Congress have the power individually to originate the amendment of errors. So there's no question that Article 5's state-initiated process is supposed to be the end run around Congress, and it would make no sense to interpret the power of Congress relative to the state-initiated process as able to dictate the substance.
Well, I think that the two answers you've just heard would lead to utter paralysis for those people who want really to have an Article 5 convention, something that I said I'm at least open to thinking about. That is, how is it ever going to happen? As a practical matter, I do agree that Article 5 should be read to oblige Congress under certain circumstances, which I can't fully define, but there have got to be circumstances. Suppose all 50 states were to petition Congress to convene a convention to consider amendments to restrict or overturn Citizens United. Suppose it was phrased that way. Now, obviously, at that point, it would be political suicide for members of Congress to thumb their nose at these 50 state calls. At that point, if there really were to be a convention, I would agree with my colleague Larry Lessig that under the necessary and proper clause, Congress would at least have authority to enact facilitating legislation. I don't think that legislation would have the power to prevent the convention from proceeding. I think that it would have to facilitate it. And I agree that the line between facilitation and prevention may be hard, and I don't think the U.S. Supreme Court would get involved in the act. But there's an awful lot of constitutional law that is made outside the Supreme Court. What constitutes an impeachable offense? When has the president unlawfully taken the nation to war? We resolve those questions through political struggle and through dialogue and conversation of the sort we are having here, not necessarily through litigation. But I think if we take the position that Congress is powerless to actually act on these applications by saying, all right, here's how the delegates might be chosen, here's how the money to pay the delegates would be raised. If Congress can't even do that, so that there'd be a first meeting at which the convention could then create its own rules of proceeding, then we would basically be at ground zero. And I don't think that that's a reasonable way of interpreting Article 5.
Okay, to my right.
Yeah, my name is My name is Raymond Latta. I'm the author of the op-ed piece, Two Constitutions, Two Futures, that appeared in the Harvard Crimson on Thursday. A brief statement and a brief question. My statement is that I think it's unconscionable that the real alternative to the problems that we face in this society and the world, that is the Constitution for the new socialist republic of North America, is not being taken up here. This is a vision and a viable plan for a liberatory society that would be tackling and overcoming racism and the oppression of women, that would be developing an economy that speaks to the great interests of humanity and protects the ecosystems of the planet, and that would be contributing to create a world in which human beings could truly flourish. And I'm here to discuss and debate that with people. My second point is a question. Why is the Harvard Law School legitimating the states' rights spouting white supremacist Tea Party patriots? Thank you.
I'm not sure we have an answer to that question on the...
I don't think it calls for an answer.
So I will call on the question to the left.
I don't know if I really have a question. I just want to make a comment based on the information I've processed.
John, can you just say who you are?
My name's John D. Herrera. I'm a political activist from California. I gathered by the raising of hands earlier that a lot of people are upset with governance. And if you look at the Declaration of Independence, I think you could characterize that we're all suffering a long train of abuse. And so I submit that the Convention Clause is actually the Article 5 Convention, or the Convention Clause is the Declaration of Independence written into the Constitution. And for me, the line in the sand is the electronic voting machines. You know, we have 80% of the country voting on these machines, and they're all on proprietary source code. And
So we really need a question.
Okay,
so if you want to say something, you have to say it as a question.
Basically, that was it. And just to say that I'm in favor of an Article 5 convention.
Okay, any response? Fine, to my right.
So we've had one
Mr.
federal-
Snyder.
Hi, Jim Snyder, a non-residential fellow at the Safra Center. So we've had one federal constitutional convention in the United States, but we've had 233 state constitutional conventions. And one of my worries is that the way you rise to the top in academics is generally to study national politics, and you associate the study of state and local politics with community colleges and state schools. And in much of your writing, I just haven't seen any discussion of America's quite extensive state constitutional convention experience. Is there anything that you feel you could learn and apply to the problems you're addressing here from our really quite extensive experience with state constitutional conventions where they've worked out most of these problems? Obviously, the legal regime is quite different, but still, there might be something valuable there, and I'm wondering if any of you would agree that there might be.
Let me first ask, Barbara, this is the subject of a chunk of the book, maybe not your chapters, but...
Yeah, this is chapter 5 in the book. In fact, it answers your specific question, what can state conventions teach us? And we don't have time to go into all of the details, but it addresses each and every one of those types of questions that Professor Tribe raised about how do you select delegates, what are the limits on the convention, what do you do after that? So I would highly recommend that, along with, I think, what would answer Sink's first question, a book by my colleague Larry Sabato at the University of Virginia, some of you might know, called A More Perfect Constitution, 23 Proposals to Revitalize Our Constitution and Make America a Fair Country. He spells out all of Professor Tribe's questions, and first of all, those are just important food for thought. But he also talks about some of these institutional questions that we're raising beyond specific public policy issues.
Yeah, brief.
Let me just say a word about that. First, I think it's not correct to think that there aren't a lot of people who are studying state constitutions. It's a burgeoning, almost cottage industry at Harvard, Yale, Chicago, Virginia, Stanford, Duke, a lot of places. Secondly, I do think there are lessons to be learned, but there are different lessons. The states as laboratories teach us lots of different things, but they don't give us answers in the national, quite different context where we have considerations of federalism that you don't have with an internal state convention, and where the issues of scope are just totally different. So they're suggestive of some options, but I don't think they help us resolve the unanswered questions.
Okay, to the left.
My name is Anthony Hawks. I'm a practicing attorney in Washington, D.C. First, I'd like to compliment Professor Tribe for consistency. I think his comments today mirror what he told the California State Legislature 32 years ago. But they also trouble me because they remind me of Robert Bork's famous comparison of the Ninth Amendment to an ink blot. The idea being that you can't enforce or apply a provision because you can't possibly know what it means. What we discovered over the last 30 years, though, is a great deal of legal scholarship. We know a lot about the Ninth Amendment now, and I think Mr. Dranius would concur. We know a lot more about the Article 5 Amendment, Article 5 provision. So my question to Professor Tribe is, did you think Article 5 was an ink blot 30 years ago? And do you still think, and if so, do you still think that's the case in light of all the scholarship that has taken place?
I've never thought that the provision of Article 5 for a new convention should be disregarded the way Robert Bork thought the Ninth Amendment should be. In that sense, I've never thought either of them was an ink blot. Remember, it was his position that because nobody knows what the unenumerated rights of Americans are, that they have none. And I've always thought that the whole point of the Ninth Amendment was that we have all kinds of rights that were never written down. And I profoundly objected to the idea that the Constitution's interpretation would be entrusted to someone who thought that we have no rights except those that are expressly enumerated. I would also object very much to someone who said that because I don't know the answers to all of the questions about an Article 5 convention, I would oppose ever having one. And that's why I've made very clear that I don't take that view.
Okay, to the right.
I'm Jonathan Marks, non-residential fellow at the Safra Center. I have a concern that the Constitutional Convention wouldn't address things which, international legal norms which have emerged long since the Constitution was drafted, such as the right to vote, under which the current position in relation to D.C., Washington, D.C., is simply indefensible. But my real question is, how can we prevent moneyed and powerful special interests from influencing the 700 delegates, both in terms of agenda setting and in the deliberations that follow? This wouldn't be a runaway convention, rather, but a very tightly controlled and orchestrated one.
If I may respond, how do we stop it from influencing Congress right now? I mean, you have to think in terms of relative risk. The status quo, whether you look at it from the right or the left, in Washington is a runaway convention. Depending on your perspective, it's 70 years old or 30 years old. All that same influence you're worried about happens every single day in Washington. It's the way of doing business. What is beneficial, relatively, about a convention of the states is that it would be your state legislators, according to our research, very detailed research. By the way, it's available at our website, goldwaterinstitute.org/Article 5. Basically, state legislators would dictate how the convention would operate in all substantive ways. And for better or worse, your state legislator is right down the street. You can run into them at the 7-Eleven. And relative to your influence on your congressman, it's not perfect, but it's a little better.
One advantage of lottery selection is that it comes close to solving your issue. There are no elections to buy, and then you have bribery rules, which I'm confident could be enforced. And you really do rely on the integrity of the delegates in the same way that you rely on people chosen for juries. Now, you may or may not trust the jury system, but that's the argument for a jury system.
John, did you want to say?
The question was about special interests, or as Madison called them, factions. And fundamental divide is what you do about factions. Yes, they are a threat to liberty, but as Madison said, you can either try to get rid of them or control them. And he gave all kinds of reasons why you can't get rid of them, because it destroys liberty, and the only check then is to control them. And I think that's a fundamental issue. The idea that we can get rid of all the bad things in politics if somehow we all come together in a convention. I don't even know how we would get the convention, because Nick says here that you can limit a convention. Well, if you limit the convention, that's got to be in the call. If it's in the call, we're not going to agree, because there will be different calls and they'll be divided. You can get around that by just having every state ask for a convention with no specificity to it, and that's what gives rise to the fear of a runaway convention. It may be that historically it shouldn't be a runaway convention, but I'm not at all confident that when you get all these special interests in there, which you will, there's no way to keep them out, that you will get what you think you're going to get.
I'm on your side, Nick, but no. We have another question from the left.
Ramon Buehler, director of the Madison Amendment Coalition. I've traveled around the country for the last couple of years talking to state legislators, and runaway convention is the problem that stops many of them from considering Article 5. So my question to the panelists, for anyone who wants to comment, is first of all, if you want a convention, if you want to see an Article 5 convention convened, would you prefer one with no limits, or would you prefer one limited to to 2 topics, for example, or to 1 topic, or to an up or down vote on a specific amendment? And for those of you who are unsure about whether a convention can be limited, what's your thought about the idea of 13 states passing a state constitutional amendment that would make it unconstitutional in that state for the state to even consider the ratification of an amendment from a runaway convention, i.e. An amendment from a convention that has ignored the instructions of the states that called it to limited scope?
Yeah, let me touch on the first one. The second one raises, I think, 2 complicated issues for the time we've got. There are some issues that really could be resolved on their own. I mean, one of the defects of the Constitution is that it doesn't provide for continuity in government should there be a catastrophic attack. There is, in fact, a proposal agreed on by the American Enterprise Institute and the Brookings Institution. This is about as nonpartisan an issue that you can imagine. I presume that all of us agree that it would be a bad thing if there were no functioning national government at all following a successful attack on the Capitol and the White House. Congress has not acted. Now, there are a number of, we could have another panel on why Congress hasn't acted, but I can imagine a single issue constitutional convention about that. Everybody would go home, end of the discussion. On the other hand, one of my hobby horses has become Inauguration Day. I think it's really, really dumb to wait 11 weeks after an election that might repudiate a sitting president during time of war, during an economic crisis. The successor, whether it's Ronald Reagan or Barack Obama, should be inaugurated much more quickly. I love the 20th Amendment because it actually recognized this kind of specific. But if you really start talking about moving Inauguration Day up, you get into the Electoral College and you get into other issues. So at this point, the Constitution is a lot like a sweater, that you think you're unraveling the one strand, and then you discover as you go along that your whole sleeve is falling off. So I think we really do have to figure out to what extent is, the thigh bone connected to the hip bone, et cetera, so that any serious discussion will lead you to Philadelphia and the kind of comprehensive overview, and what kinds of issues really are standalone. And then our condemnation of Congress would be that either, my own preferred explanation is they're just too busy with other things. I don't think they're evil, venal people. I think this is not on their radar screen. They didn't want to think about the problem of continuity in government. But it's very easy to imagine that as a standalone issue. I suspect all of us could come up with a particular standalone issue, but others just are not standalone.
So we'll do that as an assignment over lunch. I want to thank the panel and the audience. With one exception, we stayed to our principle of civil and serious discussion. So please join me in thanking them, and I look forward to the panel in the afternoon.
Thank you. That was